Hello, my friends, and happy Thanksgiving. It is so amazing to be back with here. It is so amazing to be back with y'all here on YouTube Live. It's great to see you all this holiday. Happy Thanksgiving. But the news never stops, my friends. The news never stops, not even for the holidays. So I'm here to report some breaking news that was reported yesterday on November 27th. A California federal judge says that Vanderpump Rules star Lala Kent is neglecting a deadline in her trademark case against a cosmetic consultant that Lala accuses of having run Give Them Lala without her permission. So, for those of you who do not know, Lala Kent, whose given name is Lauren Birmingham, rose to fame on a television show that I'm sure many of you have heard of called Vanderpump Rules. Back in September, Lala launched a lawsuit against Cosmetic LLC, which is a cosmetic consultant that Lala says after a failed deal, they began to infringe upon her trademark and have invaded her rights of publicity, so she alleges. So I'm going to first pull up the complaint in the case that Lala filed in September. And also now, just this week on Monday, the 25th of November, the California federal judge has issued what's called a rule to show cause against Lala. And it's basically requiring Lala to set forth proofs and cause as to why the court should not dismiss this lawsuit that she has brought against Cosmetic LLC. The rule to show cause places that burden back on the plaintiff. For instance, if a plaintiff in a lawsuit misses a deadline. Now, the plaintiff in a case is the person who files the suit. The defendant is the person who the suit is filed against. So let's go ahead, friends. I want to go ahead and pull up the complaint so that I can show you this directly. I always feel that a picture is worth 1,000 words. So I'm going to pull up the complaint here and show it to you for that was filed by Lala Kent against this LLC. So as you can see on the fronter of in the caption, we call it in the legal world, the caption, it's Lala Kent Inc., a California corporation, versus the defendant, Cosmetic LLC. Now, the meat of this, a large part of complaints that are filed are setting forth the parties, who's the plaintiff, who's the defendant, also then the jurisdiction and venue. Jurisdiction meaning, does the court even have the right or ability to adjudicate this matter? So it is always essential to set forth the jurisdiction and the venue up front. So I'm just going to briefly go through here. When we look at what Lala filed back in September, the plaintiff is a corporation that's organized under the laws of the state of California. Principal place of business, 1801 Century Park, Suite 2500 in Los Angeles. Plaintiff is the successor in interest to Lala Kent LLC. So plaintiff is the owner of the Give Them Lala trademark, United States Patent and Trademark Office, serial number 88077734, the trademark. And defendant is a corporation that, on information and belief, is organized and headquartered in New Jersey. Interesting. So Lala seems to have been dealing with a company that is across the country from her. So that's actually really interesting. So the allegations, in short, is that after a failed business venture, Lala is saying that this New Jersey corporation, Cosmetic LLC, began to infringe upon her trademark, Give Them Lala, and also to invade her right of publicity. So let me go ahead and real quickly talk with you about the overview of the case. If you don't know, Lala Kent, whose given name is Laura Birmingham, rose to fame on the reality show that was named after the former Real Housewives of Beverly Hills cast member, Lisa Vanderpump. The show is called Vanderpump Rules, and I'm sure you've all heard of Scandival that happened on season 10 of Vanderpump Rules. Kent is widely has widely promoted her brand on TV, and she owns the registered trademark Give Them Lala, which has primarily been used in the cosmetic space. Cosmetic is a company that's headquartered in New Jersey. They entered into an agreement with Kent in 2019 to develop, market, and sell cosmetics, creating Belle Vierge LLC for the venture. Kent agreed to be brand ambassador and retained the right to ensure all products and marketing reflected her personal brand, according to the complaint. So, in addition, under the agreement, Cosmetic was prohibited from manufacturing or selling any products without the reality star's express written approval, the complaint states. So, by 2021, Belle Vierge dissolved operations, but Lala says that Cosmetic refused to follow its termination obligations and continued to use her intellectual property to sell cosmetics. So around July 30th, the company introduced a new product referred to as a matte plus moisture lip wand with the Lala intellectual property that was listed for sale on the Give Them Lala website and marketed on Instagram. Ken says this was without her consent. So these allegations are really interesting to talk about the importance of, in business, of trademark, of intellectual property. Oftentimes, a lot of the things that a company owns are not always tangible, but you own, for example, the goodwill in your business or the reputation that your business has. You can own these marks or these logos that signify to the public a brand recognition. So when another company is therefore using your trademarks to carry with it and signify your business reputation, your business goodwill, your brand recognition, that company who is allegedly infringing upon your trademark can be profiting greatly. A lot of times customers will buy something because they do believe that it is affiliated with a certain celebrity or a certain company that they want to support. So this is the gist of Lala's complaint against Cosmetic LLC. The federal California judge on Monday, November 25, has said that she missed a deadline that was imperative for moving this case forward and has issued the rule to show cause. I'm going to go ahead and show you that rule to show cause briefly, just so that you can see exactly what a rule to show cause looks like. Here, if you look at this actually is the rule to show cause that was issued on Monday by the California judge that is overseeing this dispute. It says a plaintiff is ordered to show cause why this case should not be dismissed for lack of prosecution. The below time period has not been met. Accordingly, the court on its own motion orders the plaintiffs to show cause in writing on or before December 11, 2024, why the action should not be dismissed for lack of prosecution. This matter will stand submitted upon the filings of plaintiff's response. So this is actually a really important procedural posture because, like I said, this places the burden now on Lala to have to show the court cause for why her filing against Cosmetic LLC should not be dismissed. Moving right along here, when we look back at this complaint, the meat and potatoes of it starts on page 3. So when you look at page 3, you will see that there are some allegations set forth in an introductory paragraph. Often federal complaints, particularly, they set forth that introductory paragraph to give the court a brief summary up front as to what the case is about, so that the judge has the crux of it right up front. So if you look at what Lala filed back in September, you will see that she has stated on page 3 that it says plaintiff is the operating company of Lauren Birmingham, professionally known as Lala Kent. Miss Kent is a television celebrity, entrepreneur, business owner, model, brand ambassador, and social media influencer. Ms. Kent has been immensely successful in developing and promoting her own fashion, beauty, and other products, including under the Give Them Lala mark. In addition to owning the Give Them Lala mark, Plaintiff is the owner by assignment of Miss Kent's publicity rights, including her name, image, and likeness. Collectively, these rights will be hereinafter referred to as the Lala IP. So that was a lot. That was a lot of word salad. That was a lot of legalese. So let's take a moment to digest this. First of all, Lala Kent Inc. is a corporation. Okay? A corporation can own certain rights. Okay? So when we look at this complaint, Lala has set forth that her operating company is the owner of the Give Them Lala trademark and the owner by assignment. She has assigned to the company her publicity rights, including her name, image, and likeness. So I have a video that I will link in the show notes here. I will link in the description where I talked about another suit that was filed by an attorney that has represented Lindsay Lohan, filed on behalf of Johnny Bananas of the Challenge, a right of publicity suit where he was alleging that the entourage had violated his right of publicity and used his name and likeness in their character, Johnny Bananas. So he actually sued them. That suit was tossed out on a technicality. The court had found that he did not bring the suit in time and was barred by the statute of limitations in California for bringing suits of that type. But this is very important type of litigation that is common for celebrities, such as Lala Kent, such as Johnny Devananzio, or however you pronounce his last name, Johnny Bananas from MTV's The Challenge. Because celebrities there is a lot of value. There's a lot of monetary value to their name, using their likeness, using their image to advertise a product. Like I said, this is real. Like the intangibles, the intellectual property that are owned, that you have a right in as a public figure, as a celebrity, are oftentimes can be more valuable than product itself that you sell. So that's a really important concept to understand that is often hard for individuals to understand when they're not lawyers, is that you have to be very careful when you are using someone else's image or likeness. It can violate their right of publicity. It can violate, if they have a registered trademark, you need to be very, very careful that you are not infringing upon their registered intellectual property. So moving on, let's go back to this complaint here. On page 3, you will see that Lala Kent continues to state, on or around December of 2019, plaintiff and defendant entered into an agreement to develop, market, and sell cosmetics championed by Ms. Kent. Plaintiff and defendant created Belle Vierge LLC for this business venture. A copy of the operative amended, restated limited company operating agreement of Belle Vierge is attached as Exhibit A. So basically, let's digest this because this is important as well. So sometimes existing corporations such as Cosmezi LLC and Lala Kent, her company, Lala Kent Inc., they have come to an agreement and they will create what's called a joint venture. So they will then form another company. Here it's called Belle Vierge LLC, that will serve as the conduit for that particular joint venture. And that is a strategy, that is a legitimate business practice that businesses use when they want to create little houses for different business ventures. So that is what we're talking about here. So when you see Belle Vierge LLC listed in this complaint, that means that is the joint venture company that was created by Lala Kent Inc. and Cosmezi LLC to develop, market, and sell the cosmetics within this agreement that they have reached. So moving back to the complaint, back to page 3, Lala then goes on to allege that pursuant to the operating agreement, Lala Kent agreed to be the brand ambassador and had the right to ensure that the products, promotional materials, marketing plans, and distribution channels were of high quality and reflected her personal brand. The defendant was expressly, so the defendant here, which is Cosmesi LLC, was not permitted to manufacture, sell, or promote any products without Lala Kent's express written approval for any and all products developed, produced, or distributed in association with the Lala IP. The operating agreement also included a provision in accordance with which plaintiff licensed the Lala IP to Belle Liège. So it's called the license. So this is important. This is important as well to unpack these legal terms. So you can actually license out some of your, you can have a licensing agreement. You can license out some of your IP. You can license out some permissions to a company via a joint venture such as this. And that's what Lala, according to her complaint, did here. So she granted a license so that the defendant here, Cosmesi LLC, could market, sell her product in accordance with distribution channels and marketing that she determined to be high quality. So it states in her complaint that she had the right to ensure that the marketing that was used, the distribution channels that were used were of high quality. And that's important so that she could ensure that she doesn't lose any of that goodwill that her company and her brand has built up by working with this joint venture. Because it is a risk. It is a risk anytime a well-known brand who has a really good reputation is then contracting out and having agreements with another company. So that is, it appears that she safeguarded her interests in her ability to do that, and therefore she agreed to be brand ambassador. So when we go back to the complaint here, page 3, it says that Cosmesi LLC, the defendant, agreed in return to oversee operations, importation, shopping, accounting, and all other financial and accounting responsibilities. So that's important. So Lala Kent's company is serving as brand ambassador. They have the right to ensure that the products and promotional materials, marketing, distribution channels are of high quality and reflect her personal brand. And she has in the agreement that the defendant was not permitted to manufacture, sell, or promote any products without Lala Kent Inc.'s express written approval for any and all products that were developed, produced, or distributed. So, in exchange, the defendant then took on these overarching responsibilities, and then that makes it, that gives Lala Kent Inc. an incentive to move forward with this joint venture, because in exchange for what she's giving them, they're going to be handling a lot of the logistics, a lot of the things that cost money to handle or that take up time, are very time consuming to handle, such as the accounting, finances, things of that nature. So that appears to have been the agreement between them, according to her complaint. Now we're going to move on in the complaint to page 4. So let's move on to page 4. And this, we continue with the meat and potatoes of what she's alleging. It says the defendant was also obligated or obliged to provide Lala Kent Inc. with an accounting that included sales, revenues, and cost figures. So now Lala goes on to talk about Cosmesi LLC's breach and the misappropriation of the Lala IP. Here's where we get to the crux of the accusations. According to Lala Kent Inc., Cosmesi LLC consistently failed to provide plaintiff with the financial reporting required by the parties' written agreement. Okay, so she's alleging they were not giving her the sales revenue and cost figures that they had agreed to. Belle Liège dissolved by operation of its terms on December 21, 2021, which is 2 years after it had these entities had started doing business together in 2019. The operating agreement required defendant to wind down operations, sell through existing inventory and provide plaintiff with a full and complete accounting. Plaintiff repeatedly provided defendant with written notice of the termination of Belviage and the Lala license. Defendant refused to abide by its termination obligations under the operating agreement and continued to use the Lala IP to develop, market, and sell the product. In good faith attempts to avoid litigation, Lala Kent Inc. made many attempts to secure Cosmesi LLC's compliance with its contractual obligations. By its counsel, by and through its counsel and CEO, they notified defendant of its contractual responsibilities in various letters in 2023 and 2024. In late 2023 and early 2024, defendant represented that it would abide by its contracted commitments, sell off existing inventory, and dissolve Bella Viage. So that was in late 2023 and early 2024, allegedly. The Cosmesi LLC ultimately refused to live up to its promises to cease sales, according to Lala. And on or around July 30th, 2024, without Lala Kent's consent, Cosmesi introduced a new product branded with Lala's IP, intellectual property. Specifically, defendant introduced a new matte and moisture lip wand product, unlicensed product, in connection with the Give Them Lala brand. The unlicensed product is listed for sale on the website www.givethemlala.com and marketed on Instagram under the @GiveThemLala beauty account. Oh my heavens. So there she's saying, so let's unpack this, okay? Let's unpack this. Okay? This is important. So under the agreement between Lala Kent Inc. and the defendant company, which is Cosmesi LLC. Cosmesi LLC had allegedly agreed to provide Lala with certain financial reporting. Lala and her company are alleging that Cosmesi LLC failed to do that they did not live up to their financial reporting requirements, and that therefore she notified them that she's terminating Bella Viage, their LLC, their joint venture company, and that she is terminating their license to be able to use her intellectual property. Now, further, Lala Kent is further alleging that Cosmesi LLC did not live up to their obligation to terminate using her intellectual property, but rather they then introduced a matte and moisture lip wand product that's connected with the Give Them Lala brand. So I mean that's a very crux of this case. She's saying not only did you cease to stop using my intellectual property in violation of my rights, but you then launched a matte and moisture lip wand product that is associated with my brand, Give Them Lala, and that is actually marketed and sold through the Give Them Lala beauty Instagram account and is available on the Give Them Lala website. So she's alleging various violations of her rights. So back to the complaint here. When we move forward, we will see on the next page of the complaint. Let me actually move this through for you, friends, so you can see. On page 5 of the complaint, Lala continues to assert that the introduction of a new product constitutes a breach of the license agreement and a gross intentional misappropriation of plaintiff's intellectual property. Any and all rights that defendant had under the Lala license expired long before defendant released the unlicensed product. The unlicensed product would constitute intellectual property theft, even if the Lala license had not expired, which it did. Lala alleges that Section 3C4 of the business plan limits the Lala license to products that are expressly authorized by plaintiff. The company shall not manufacture, sell, distribute, or promote any products or materials utilizing the Lala LLP without Lala Co.'s prior written approval as to the products, the promotional materials, marketing plans, and distribution channels. So Kent alleges that she did not provide prior written approval for the sale or marketing of the unlicensed product. Indeed, plaintiff was not even notified that the unlicensed product was distributed. Plaintiff first learned of the unlicensed product with the general public after it was advertised by Cosmetic LLC on the @Give Them Lala Beauty Instagram account. Oh my goodness. Defendants' continued use of the Lala IP and its failure to provide financial reporting constitutes a breach of the operating agreement and a violation of state and federal law. So once again, that's a mouthful. Let's unpack this. So Lala is saying, number one, not only did you continue to use my intellectual property, but even if, which has expired, she says this licensing agreement has expired. But even if our licensing agreement had not expired, she alleges that Cosmetic LLC would still be violating the operating agreement because the operating agreement requires her express written permission to promote, sell, market a product via their joint venture. And Lala Kent Co., according to this complaint, did not provide that permission with respect to the matte and moisture lip wand that is at issue here, that the complaint refers to as the unlicensed product. So Lala is saying, not only did I not give you my express written advance consent to sell and market this matte and moisture lip wand, but you not only did I not give you permission to do that, but I then only learned about your release of this new product with the rest of the general public when it was starting to be advertised on the @Give Them Lala Beauty Instagram account. So that's if these allegations are true, that's a pretty offensive and flagrant situation here. So on the next, as we scroll down here on page 5, we see the first claim for relief is breach of contract. So Lala Kent Inc. says that she has performed all obligations required under the operating agreement. Okay. She says that the defendant, Cosmetic LLC, has material breached the agreement by failing, here, let's go on to the next page, has materially breached the agreement by failing to provide financial reporting and by continuing to use the Lala IP subsequent to the termination of the Lala license. So as a direct and proximate result of defendant's breach and continuing breach, plaintiff has suffered and continues to suffer great irreparable injury and damage in an amount to be determined at trial. When you scroll down on page 6, the second claim for relief, trademark infringement under the Lanham Act, Section 32. The Lanham Act is a federal. The Lanham Act is a federal statute that relates to business practices. I remember I actually am a practicing attorney myself, though none of this information on this channel is legal advice. I'm not giving legal advice. I'm giving legal commentary. However, when I was working at a law firm doing litigation that involved unfair competition, copyright, trademark issues, Lanham Act was often brought up. And there are also, in addition to federal statutes that relate to unfair competition, deceptive advertising, trademark infringement, copyright infringement, there are also a plethora of state laws as well that relate to these topics. So let's move back to the complaint. We're going to look at her second right to relief. She states her second claim for relief is trademark infringement under the Lanham Act, Section 32. Lala Kent Inc. alleges that Cosmesi LLC's wrongful use of the Give Them Lala trademark comprises an infringement of Lala Kent Inc.'s registered trademark, Give Them Lala, and is likely to cause confusion, mistake, and deception of the public as to the identity. Such use by defendant of the infringing Give Them Lala mark deceives and is likely to deceive others into believing that defendant's products are sponsored by, approved by, or affiliated with the plaintiff. They're likely to devalue the Give Them Lala and therefore constitute trademark infringement in violation of the Lanham Act, Section 32, 15 U.S.C. Section 1114. Plaintiff has been and continues to be damaged in a manner that cannot be fully measured or compensated in economic terms and for which there is no adequate remedy at law. The actions of defendants have damaged and will continue to damage plaintiff's rights, reputation, and goodwill. Such irreparable harm will continue unless defendant acts as restrained and or enjoined during the pendency of this action thereafter. Plaintiff believes and alleges that Cosmesi LLC has committed the infringement described above, knowing that its unauthorized use of the registered trademark is likely to cause consumer confusion. Defendant has thus willingly, knowingly, and maliciously deceived and confused the relevant consuming public, such the plaintiff is entitled to an award of treble damages. So let's unpack this. Let's unpack this second claim for relief under Lanham Act, Section 32. The plaintiff once again is saying, hey, look, the actions of Cosmesi LLC are misleading the public into believing that this matte and moisture lip wand that Cosmesi LLC has released, infringing upon the Give Them Lala mark, is likely to confuse the general public into believing that this product is associated with and approved by Lala Kent Inc. And she says, this damages me. You know, under this operating agreement, I had the right to expressly authorize product before this other company, Cosmesi LLC, would sell it using my intellectual property, and they breached the agreement. That's what Lala Kent Inc. alleges. So that is, again, a very important distinction, is that when you are using another company's mark and infringing upon their trademark, their registered trademark, you are likely to cause confusion in the general public as to who is associated with this. Is this associated with that celebrity? Is it associated with that trusted brand that you as a consumer want to support? So this lawsuit that Lala has raised has a number of really important issues associated with it. So finally, we're going to go to page 7 of the complaint. And Lala continues to allege that Cosmesi's actions have further caused and will continue to cause irreparable injury to her, and that the court needs to enjoin them. She is asking the court to stop. Enjoin is another fancy legal word for stop. She's asking the court to put a stop to the defendant's ability to do this. The third claim for relief is violation of statutory rights of publicity under California Civil Code Section 3344. So Lala Kent Inc. is the owner of all rights of publicity to Lala Kent's name, image, likeness, and persona. So remember, at the beginning of this complaint, Lala had alleged that she assigned her rights of publicity to her name, image, likeness, persona over to Lala Kent Inc., this company, this operating company. Okay, so again, her complaint now is alleging a third claim for relief, violation of the statutory right of publicity. So Lala Kent's corporation is alleging that the defendant, Cosmesi LLC, has willfully and without authorization use Lala Kent's name, image, likeness, and persona for commercial purposes to advertise the cosmetics and sell cosmetics. Cosmesi LLC's unauthorized use of Lala Kent's name, image, likeness, and persona constitutes a commercial misappropriation and violation of Section 3344 of the California Civil Code, according to Lala's complaint. Lala then alleges that as a direct and proximate result of Cosmesi LLC's wrongful conduct, her company has suffered and will continue to suffer damages in an amount to be proven at trial. The defendant, Cosmesi LLC, has further been unjustly enriched by its misappropriation of Lala Kent's statutory right of publicity. Therefore, plaintiff is entitled to restitution and all income, profits, and other benefits resulting from Cosmesi LLC's conduct in an amount to be determined according to proof at trial. The defendant's action is alleged above, were malicious, oppressive, and fraudulent, and done with the intent to injure Lala Kent, Inc., and with a willful and conscious disregard for plaintiff's rights. As a result, Lala Kent, Inc. is entitled to recover from Cosmesi LLC punitive and exemplary damages in an amount sufficient to punish and deter it and others from engaging in such acts in the future. And Cosmesi LLC actions have further caused and will continue to cause irreparable injury to Lala Kent, Inc. that cannot be remedied by an award of monetary damages alone. Plaintiff is therefore entitled to preliminary and permanent injunctive relief, preventing the continuing infringement of her rights of privacy. So that's a lot, friends. Let's unpack this. So basically, first, let's talk about a term that Lala Kent's company used in this complaint called unjust enrichment. So that's a concept under the law that when a company has experienced the benefit that they were not entitled to because of their bad actions, they can be termed to be unjustly enriched. And therefore, Lala Kent Inc. is saying, we have a right to restitution. We have a right to be paid that income. And that money that Cosmesi LLC is unjustly getting due to their infringement upon our Lala Kent intellectual property. Then they ask for punitive damages, which is a type of damages that is meant to go beyond just compensating, go beyond just compensating someone for the wrongdoing of the defendant, but to actually go beyond that and punish the defendant. So there are there are more than two types of damages, but let's talk about two main types of damages. There's compensatory damages that are meant to compensate the person filing the lawsuit for any wrongdoing that has been found by the defendant, to make them whole again, compensate them for what the plaintiff lost. But then there's also a type of damages called punitive damages. And punitive damages, as their name suggests, are meant and intended to punish the defendant, to punish the wrongdoing party, so that it will deter that defendant and deter other people, other actors, from similarly acting in the future. It's meant to send a message that, like, hey, if you mess with a plaintiff in this way, you violate the law in this way, you're going to get punitive damages imposed upon you. Okay? And then she's also saying, hey, look, an award of monetary damages is not even enough here, Your Honor. Lala Kent is saying in this complaint, you also need to enjoin, meaning stop, Cosmesi LLC from violating my intellectual property in the future. So monetary damages are not enough, she's saying. I also need the court to impose injunctive relief. Injunction means cease, to stop. She wants the court to impose an injunctive stop on Cosmesi LLC from infringing upon her trademark in the future. So that was a lot to unpack, but we are going to move on to the final page of, let's see, it may not be the final page, friends. Let's see. So next, we have a fourth claim for relief. We have another claim for relief, which is a violation of common law right of publicity. So let's unpack that. So different states, in this case, California has a civil code, section 3344, that gives a state right to relief for violation of the right of publicity. But Lala is also bringing a fourth claim for relief under common law, invasion of right to publicity, violation of right of publicity. So common law, when you see the word common law, it means like it's not, the right is not set forth in the statutory law, meaning it's not set forth in the statutes, right? But it's set forth through case law, right? So there's two types of law. We have there's many types of law actually, because we have administrative code, we have statutes, we have rules and regulations. But to be very fundamental here, we have rights that stem from being set forth by statute, right? By our laws, that you can open up the book, the statutory books, and read them right there. It's section, 3344 California Civil Code. But there is also an entire body of law, which is decisional law, common law, that is handed down by judges. And basically over the years, as courts rule and as courts make decisions, precedent is set. We've all heard that word, precedent is set. And there are certain rights that therefore stem from common law as well. So Lala Kent's attorneys are being very diligent. They're alleging all causes of action on her behalf, both statutory violation of the right of publicity and common law violation of her right of publicity, of her company's right to publicity. So we're going to go ahead now and continue on to read about this fourth claim of relief. Lala Kent's company alleges that it is the owner of all rights of publicity in Lala Kent's name, image, likeness, and persona. They say the Cosmetic LLC has willfully and without authorization used her name, image, likeness, and persona for commercial purposes to advertise the cosmetics and sell cosmetics. So again, she's alleging that they have been unjustly enriched, and that she is entitled to preliminary and permanent injunctive relief. The next cause of action, the fifth claim of relief, is under the Unfair Business Practices, California Business and Professions Code, section 17200. OMG, Unfair Business Practices, California Business and Professions Code 17200. The reason why I'm saying it like this, friends, is that when I was practicing at a large law firm, we had a California case that was in the news that was pursuant to section 17200. So I'm very familiar with this Unfair Business Practices statute, and it really brings me back home and hits home for me. So my friends, let's look at this in the complaint. Let's see what Ms. Lala is alleging here. She says that the acts of Cosmetic LLC constitute fraudulent and unlawful business practices as defined by California Business and Professions Code section 17200. These acts and practices by the defendant, Cosmetic LLC, are likely to mislead or deceive the general public, and they therefore constitute fraudulent business practices. And the above described acts constitute unfair competition as well under Section 43A of the Lanham Act. These unlawful and fraudulent business practices described above present a continuing threat to and is meant to deceive members of the public in that defendant continued sales wrongfully trade on the goodwill of plaintiff and Lala Kent. And as a direct and proximate cause of these acts, the defendant, Cosmetic LLC, has received and will continue to profit from plaintiff's intellectual property and goodwill. As a direct and proximate cause of Cosmetic's acts, the plaintiff has been injured and has lost money, profits, and goodwill, and such harm will continue unless the defendant's acts are enjoined by the court. Plaintiff has no adequate remedy at law for Cosmetic LLC's continuing violation of Lala Kent Co.'s rights. The defendant should be required to restore to Lala Kent Inc. any and all profits earned as a result of its unlawful and fraudulent actions, or provide plaintiff with any other restitutionary relief as the court deems appropriate. The sixth cause of action is unjust enrichment. We've talked about that. And then seventh claim for relief is accounting. Lala Kent Inc. alleges that a relationship exists between Lala Kent Inc. and Cosmesi LLC that requires Cosmesi LLC to provide an accounting upon information and belief. A balance is owed to Lala Kent Inc., which can only be ascertained with an accountant. And therefore, the plaintiff prays for judgment as follows: an award of compensatory and treble damages in an amount to be proven at trial, the disgorgement of defendant's profits attributable to the infringement of plaintiff's intellectual property, including the rights of publicity, and the award of punitive damages in an amount sufficient to deter unlawful conduct by defendant in the future. And then this is signed off on at the end by her attorneys. Let's go to the last page here. This is signed off for by her attorneys, Fox Rothschild. And as you all may recall, so this is signed by Jeff Grant, Matthew Follet, attorneys for plaintiff Lala Kent Inc. They have demanded jury trial. And this is interesting because as you all may recall, Send It to Daryl, which was Lala's very famous tagline. It was a very famous on her merch. Send It to Daryl. Daryl was also a attorney at Fox Rothschild on that team. So it's really cool to see who she is working with. So friends, it has been so great to see you all on this Thanksgiving. Thank you for, breaking down this legal news with me. This news just dropped yesterday. So here on Reality Suits News, I will be following the celebrity and media and entertainment news stories that are dropped. I will provide them to you timely. I have another live stream coming up later on tonight in regards to the Brad Pitt and Angelina Jolie continued litigation drama. A court is now forcing Brad Pitt to turn over documentation that Angelina Jolie says will prove that he concealed domestic violence to herself, allegedly, and to their children. That's her allegation. So that has been reported in legal news recently, and I will be breaking down those legal documents as well, just as I did here today for the Give Them Lala trademark case. Lala Kent Inc. v. Cosmesi LLC. I do ask that if you got value from the stream to hit the subscribe button, because that gives great support to our channel. And I will be looking forward to seeing you all in our upcoming streams. Thank you so much. I'll see you guys soon. Bye-bye. Bye, friends. Happy Thanksgiving.